Allegations in a pleading. What is the manner of making allegations? Let us begin by discussing ultimate facts. The manner of making allegations in general dictates that every pleading shall contain, in a methodical and logical form, a plain, concise, and direct statement of the ultimate facts on which the party pleading relies for his claim or defense, as the case may be, omitting the statement of mere evidentiary facts. What is the difference between ultimate facts and evidentiary facts? Ultimate facts refer to those which directly form the basis of the right sought to be enforced or the defense relied upon. The rules of procedure require that the complaint must make a concise statement of the ultimate facts or the essential facts constituting the plaintiff's cause of action. A fact is essential if it cannot be stricken out without leaving the statement of the cause of action inadequate. A complaint states a cause of action only when it has its three indispensable elements. Do you remember? These are: number one, a right in favor of the plaintiff by whatever means and under whatever law it arises or is created. Number two, an obligation on the part of the named defendant to respect or not to violate such right. And number three, an act or omission on the part of such defendant violative of the right of the plaintiff or constituting a breach of the obligation of the defendant to the plaintiff for which the latter may maintain an action for recovery of damages. In short, if the ultimate facts are not alleged, the cause of action would be insufficient. Ultimate facts must be distinguished from evidentiary facts, which refer to those which are necessary to prove the ultimate fact or which furnish evidence of the existence of some other facts. Now, what is the test of the sufficiency of the facts alleged in the complaint? It is well to point out that the plaintiff's cause of action should not merely be stated, but importantly, the statement thereof should be sufficient. This is why the elementary test in a motion to dismiss on such ground is whether or not the complaint alleges facts which, if true, would justify the relief demanded. As a corollary, it has been held that only ultimate facts and not legal conclusions or evidentiary facts are considered for purposes of applying the test. This is consistent with Section 1, Rule 8 of the Rules of Court, which states that the complaint need only allege the ultimate facts or the essential facts constituting the plaintiff's cause of action. A fact is essential if they cannot be stricken out without leaving the statement of the cause of action inadequate. Since the inquiry is into the sufficiency, not the veracity, of the material allegations, it follows that the analysis should be confined to the four corners of the complaint and no other. The test of the sufficiency of the facts to constitute a cause of action is whether, admitting the facts alleged, the court could render a valid judgment upon the same in accordance with the prayer of the complaint. In answering this query, only the facts asserted in the complaint must be taken into account without modification, although with reasonable inferences therefrom. Let's discuss an example: an action for reconveyance. So with respect to the purported cause of action for reconveyance, it is settled that in this kind of action, the certificate of title is respected as incontrovertible. What is sought instead is the transfer of the property, in this case the title thereof, which has been wrongfully or erroneously registered in the defendant's name. So what is a sufficient allegation of the ultimate facts for the action of reconveyance? All that must be alleged in the complaint are two facts which, admitting them to be true, would entitle the plaintiff to recover title to the disputed land, namely, number one, that the plaintiff was the owner of the land, and number two, that the defendant had illegally dispossessed him of the same. Okay? So after discussing ultimate facts, the question comes, what are not ultimate facts? A pleading should state the ultimate facts essential to the rights of action or defense asserted, as distinguished from mere conclusions of fact or conclusions of law. For example, if it is a case of the validity of a contract, general allegations that a contract is valid or legal or is just, fair, and reasonable are mere conclusions of law. Likewise, allegations that a contract is void, voidable, invalid, illegal, ultra vires, or against public policy without stating facts showing its invalidity are mere conclusions of law. So what are not ultimate facts? Legal conclusions, conclusions or inferences of facts from facts not stated, or incorrect inferences or conclusions from facts stated. An allegation that a contract is valid or void, as mentioned, is a mere conclusion of law. Also not considered as ultimate facts are evidentiary or immaterial facts, such as the details of probative matter or particulars of evidence, statements of law, inferences, and arguments. What if there is an insufficient allegation of facts? By merely stating a legal conclusion, the complaint presents no sufficient allegation upon which the court could grant the relief the plaintiff prayed for. Thus, said pleading can be dismissed on the ground of failure to state cause of action.